Good afternoon, everyone, and thank you for joining us today. My name is Christina Rose, Director of Strategic Alliances at Foundation Source, and I will be facilitating today's webinar discussing estate planning with a private foundation. Before we get started, I want to send my best wishes to you, your families, and your communities. I'm pleased to be joined by Jodi F. Krieger, partner at Kleinberg, Kaplan, Cohen, and Wolff, and Jeffrey Haskell, Chief Legal Officer at Foundation Source. It's a pleasure to have them with us today to talk about how a private foundation can help individuals and families build an enduring charitable legacy. The conversation is especially timely as we seek to find ways of supporting communities in this unprecedented time of need. For anyone not familiar with our firm, Foundation Source is the nation's largest provider of comprehensive support services for private foundations. Our services include administrative support, active compliance monitoring, tax and legal expertise, online foundation management tools, and philanthropic advisory services. I will formally introduce Jodi and Jeff in a moment, but first, a few points to note before I turn it over to them. A quick word about Wi-Fi and phone connections. Probably like most of you, we are working remotely. I don't anticipate any technical issues during the broadcast, but if one of us loses connection, just know that we will quickly get it resolved and resume the webinar. If you experience problems, you can try exiting and then rejoining the broadcast. Also, audio may be better via phone than on computer. It can also reduce some strain on your Wi-Fi connection. Questions can be submitted at any time via the GoToWebinar dashboard on your screen. We will be leaving some time at the end of today's presentation to address your questions. If we do not have time to answer all of your questions, please know that we will follow up with you directly after the webinar. Now, in the handout section of the dashboard, you will find an article that Jodi Krieger authored, appropriately titled Estate Planning with a Private Foundation. In fact, this article is what inspired today's webinar. There is also a handout that provides some additional information about Foundation Source and our work. And now it is my pleasure to introduce Jodi and Jeff. Jodi Krieger is a partner at Kleinberg, Kaplan, Cohen, and Wolff, where she specializes in helping clients with their personal charitable goals, as well as their estate and related tax planning needs. Jodi represents clients in all phases of complex estate and trust administration and advises them with respect to estate litigation issues. A native New Yorker, Jodi is a graduate of Brooklyn Law School and holds a Master's of Law in Taxation from New York University's School of Law. Kleinberg Kaplan is a premier firm that provides practical, business-minded legal counsel to investors, entrepreneurs, and other industry leaders. The firm has a full-service platform that combines extensive big law experience with the personalized attention of a boutique firm. Kleinberg Kaplan serves a broad array of clients, including investment funds, companies at all stages, real estate investors, family offices, and high net worth individuals. Chief Legal Officer Jeffrey Haskell has been with Foundation Source since its founding in 2000. Together with a team of attorneys, accountants, and support professionals, he provides tax reporting services and guidance on legal and tax issues to Foundation Source clients and their advisors. Jeff is a frequent speaker on the rules and regulations pertaining to private foundations, and his articles have appeared in several trust and estate and law review publications. Jeff is a graduate of the Benjamin N. Cardozo School of Law and holds a Master's of Law in Taxation from New York University School of Law. And he is a member of both the Cardozo Law Review and NYU Tax Law Review. And with that, Jodi and Jeff, it's my pleasure to turn it over to you. Hi, Jodi. Oh, and there's Jeff. Great.
Hello, everybody.
Take it away.
All right, Jodi, could you please start us off by letting our attendees know what topics we're going to be covering today?
Good afternoon, everyone. Today we're going to be discussing estate planning strategies with a private foundation. We hope that you'll walk away with general thoughts on when to set up a private foundation, how a private foundation can fit into your or your client's overall estate plan, and what types of assets are best for contributing to a private foundation. We will also discuss a whole host of intangible benefits. And what benefits are there when you incorporate a private foundation in your overall estate plan?
Jodi, as part of our discussion today on fitting foundations into an estate plan, are we going to be covering charitable lead trusts and charitable remainder trusts?
Actually, Jeff, although both types of trusts have their own unique benefits, there's so much to be said about incorporating them into an estate plan. To do the topic justice, it would need to be covered in its own webinar. A little foreshadowing for the future. We can, however, make available your white paper about stretching a family's control over their assets through such trusts. And with that, we'll begin the main subject. One of the first things you need to know when creating an appropriate estate plan is you must get to know your client. You're going to need a fair amount of information, and the client must be willing to share with you. So don't be shy. Ask them a lot of questions. For instance, with private foundations in mind, some are charitably inclined and others less so. You won't know unless you ask.
Jodi, we know some families that are well into their second or third generation, and they're really now very charitably inclined and forms a very important part of the family's culture, but they didn't necessarily start that way. They may have been driven by some sort of sale of a company or some other tax event that made it conducive at that moment to start the foundation. And so we see cases where foundations grow into their foundations. And that seems a little counterintuitive because maybe you'd think that in all cases, foundations have as their catalyst charitable impulses. Do you find that's the case?
Actually, Jeff, given that my approach, because of my legal experience, is from the estate planning perspective, I don't. I find that most of our clients are motivated by tax savings. In terms of the initial motivation to start a private foundation. Generally, the clients are due to receive a substantial amount of income, or they're about to realize a large capital gain, and they are looking to minimize income tax liability. But in general, they have to have some type of charitable inclination. Otherwise, no matter how much income they're going to be saving, income tax they're going to be saving, setting up a private foundation would not be interesting to them.
Well, Jodi, how important is it for you to have a handle on the family dynamics when you're formulating an estate plan?
Family dynamics are probably one of the most important aspects of whether or not you should and when you should create a private foundation. Creating a private foundation is not just drafting documents and transferring assets. It entails involvement of family members. The involvement can be very limited or it can be very intense. But at minimum, funds have to be distributed for charitable purposes every single year. So the family dynamic in terms of whether or not they share charitable interests or the creator, let's say the matriarch, patriarch, wants to support a specific interest, and yet the kids are interested in something completely different. You have to be able to get a handle on how well they will work together. Are they willing to take the foundation into both directions? Or will they take it in one direction at one point in life and another direction? There's all kinds of permutations, but family dynamics are very important. The other thing you need to understand about a family is very typical in estate planning regardless. You have to understand the personalities of the players. Is there an older son? Is there an older daughter? Are there any children? Does the younger daughter feel that she has been, pushed to the side most of her life? And therefore, in this mix, she wants to be given more of a important role here. Or, you have to understand how the personalities, because in the context of administering a private foundation, if you're going to involve a family, they have to be able to work together. If they can't, there's no point in putting them together. I've seen too many situations where after the matriarch and the patriarch have died and the siblings are to take over the foundation, they can't agree on even when to hold a board meeting. They can't agree on which accountant to choose. They basically can't agree on anything. So what ends up happening is a lot of times we will help them divide the foundation into 2 or 3, however many children are. That's not really what the founders wanted. But when you counsel your clients, you should always be aware of these things so that you can, lead them into the right place. You can't say to a client who has children who can't, make decisions together, well, this is a great idea. It'll continue for generations. Your children will do it together, your grandchildren. There's no way that's going to happen. So you need to understand those things. So, and you have to be appropriate in your advice. So.
Well, let me ask you something. When you have a sophisticated client that's no stranger to philanthropy, they may already have a clear idea of what it is they want to do with the foundation, what charitable purpose they're trying to further. But in my experience, sometimes a client will come along and they just know they want to do good things, but they don't know exactly what it is they want to do. They're kind of fuzzy on that. So what's your experience, and do you help your clients crystallize their focus, their mission, and find common ground with other family members?
We do. We do a lot of that. We help them write their mission. We help them discover their mission. We typically represent that they do some exploration prior to forming the foundation and prior to setting out their purposes and goals. And we have them, basically, what are their ideas? Let us know what they are, and we put together some type of a mission statement for them. They go through it, and we have a conversation as to, where it might go. This is not really what I was thinking. And, we'll take them through the process of crystallizing that. That being said, Jeff, missions change. Desires in what you want to concentrate your charitable goals on change all the time. So although a mission is extremely important and it should be crystallized, there's a great chance that it's going to change over time. And that's okay, because these things can be changed over time.
Well, so Jodi, let me ask you something now. Having said that, so what do you do when you have a client that does have a clear goal in mind, like medical research, for instance? And let's say they're worried that they're going to be contributing maybe a bulk of their estate or a significant chunk of assets into the foundation. And maybe they're worried, what will happen after they're gone? Will the money that they're contributing into the foundation actually be dedicated to the charitable purpose that they are so on fire about, that they care so much about? What could be done about that?
Well, before I go into that, what happens after, let's talk about a concern about when the founders are there and they're making the grants, they're choosing the projects. A lot of times they're concerned that the organizations that they give the money to may use it for something other than, or a little different. They will nuance and not use it exactly the way the board of directors, the founders, gave them the money for. What we do with our clients is we typically recommend that they enter into what's called a grant agreement. And we set out different parameters, which can include things like, the plaque on the wall, or using it for a specific type of medical research, supporting a specific project that they know is taking place. And we set all of that out in the grant agreement. So they're comfortable that what they want done with the money is going to be done, because otherwise the grantee, as they're called, would violate the terms. Now, one of the other things that makes clients very comfortable is we put in a provision that the grantee either meet with the foundation representatives or report to them periodically, so that, once the money is spent, things don't, go off track. As far as what happened,
I was going to say, I've even seen agreements. I don't know if it's in your experience, but sometimes I've seen clients negotiate that if there's going to be a change of use, for example, is to build a medical building for a university, and then they cancel the program or it's shut down, that they may need the family's consent in order to change the purpose. Is that something that you've seen?
absolutely. We set out a very specific or a general purpose, depending on what the client wants, depending on what the foundation is looking to do. And we always put a proviso that if the grantee intends to or would like to use the money for something other than the purpose stated in paragraph 1, they need to have written consent from the private foundation.
Well, I could see how a carefully drafted grant agreement would really assuage a foundation's concern that its funds will be, I don't know, misdirected or spent not in accordance with the terms of the agreement. But what about, again, going back to the donor of the foundation, the founder, and they're concerned that after they're gone, their successor will chart a new charitable course, as it were. So I could see how that would be a concern, because even if you're careful about picking someone who will be your successor, so if the foundation is going to go on for a long time and doesn't have the set lifespan, it can go on for a number of generations. And unless you're a seer or you have a crystal ball, you can't know and you can't predict who your successors down the line will be and you can't gauge their commitment to your charitable purpose. So is there anything that you could do about that?
Well, first of all, you took half of my speaking points, but I'll excuse you for that. The sunset, the picking your successors carefully, but in any event, there's a lot more to talk about. The formation documents are extremely important, and we approach them in two ways. We typically do a very general certificate of incorporation, and we set forth the specific purposes and the specific desires of those setting up the foundation in the bylaws. Okay. And we go so far as to say that so long as the founders are alive, the bylaws can be changed. However, once they're gone, the bylaws cannot. So that the people who take over are stuck with those purposes in the bylaws. And go ahead.
Well, I was going to ask, in your experience, is one organizational form better than another to accomplish this?
You know there is, Jeff. My least favorite organizational form during life, but my favorite at death for the specific purpose of not being able to change what the founder wants, is a trust agreement. A trust agreement is subject to court modification. If the purposes need to be modified, the trustees, whoever they are, be it the first line of successors, the second, the third, or the 50th, they have to go to court and they have to ask permission from the court. And there is significant court rulings, significant case law, and there is a concept called in Latin cypre that says that a charitable purpose cannot be changed unless it can no longer be fulfilled, period. So if your purpose was to cure polio, okay, and you created this foundation before polio was eradicated, all right, and the money originally was used to fund whatever research there was to cure polio. Now, if you went to court, you could get that purpose changed. Now, the court would not allow you to support Greenpeace or environmental causes. They're going to typically keep you in the realm of what the original purpose was for. Now, the original purpose was specifically for a medical research topic, and that's what they're going to keep you tied to, okay? Without the court intervention, no, you can't change the purpose of a trust, at least not in New York.
Yeah, I mean, my understanding is that the reason why a trust is better is because when it comes to a corporation, it's hard to, there's a question whether you can, in fact, tie the hands of a future board and curtail their options for amending the foundation's the corporation's charter documents. Nonetheless, we did experiment with that. A couple of years ago, I set up a Delaware corporation, and I came up with a really original name. It was like the Perpetual Foundation or something like that. And yeah, and so I actually specified, to your point, that it was meant to, the purpose of the foundation was to find a cure for human diseases, and to the extent that, or for cancer, and to the extent that that purpose is no longer applicable, at that point they would have the option to choose another purpose. But I said specifically that particular section of the certificate of incorporation was not subject to amendment. And I wanted to see if that was going to be balanced by the Secretary of State, and it wasn't. It went through. Again, it was just an experiment, and we dissolved the foundation shortly thereafter, just to see whether it would go through or not. But I don't know. I think the final analysis, and I'm wondering if you concur, was that although maybe it wouldn't have been enforceable if challenged in court, it may have been a significant disincentive, or might have discouraged a future board or successors from challenging and going to court in the first place. What do you think?
I think in my office, I have several corporations that say that the certificate of incorporation and the bylaws cannot be amended once the founder is disabled and or deceased. However, I doubt it'll ever be a test case, because with those, we have backed them up with turning those foundations into trusts upon death. And the corporate form remains until the trust form qualifies for tax exempt status. But other than that, I mean, I don't want to be the test case, so I back it up with a trust.
Where's your sense of adventure?
But if we ever become the test case, I'll let you know. For right now, everybody's been behaving.
Fair enough. But let me ask you, do you factor into
giving away my secrets?
Sorry about that. So let me ask you, do you factor in jurisdictional concerns when you're choosing one type of structure over another? And
yes.
If so, why? How so?
Okay. If I'm doing a corporate foundation, I go to Delaware. No questions asked. I want to be in Delaware. So I create my foundation in Delaware. I don't care where I'm operating. Okay? I don't care where my offices are. I always start with Delaware. And the reason I do that is because Delaware's corporate laws are extremely flexible. All you're required to have is one director, one officer, and pretty much you can write your own ticket. There's very little. And a lot of other states, they have different requirements. New York, you have to have at least 3 directors. I can't tell you how many foundations I've seen formed by others that, several years in, there's only 2 directors and they want to dissolve. And they have to dissolve under New York law, which is extremely difficult. And the most difficult thing becomes, okay, how do we get that 3rd director? And why do we have to get that? It's just, it's difficult. With a Delaware corporation, it's very simple. You shut down the corporation like you would any other corporation in Delaware, and you're done.
But with the trust, you have to actually care about nexus to the state, for example, where the grantor resides or the trustees.
Yes.
That's not an issue for corporations.
with the trust, it is typically the law of where the grantor was when he died, or the trust became, unamendable if it was part of a irrevocable trust plan. That being said, you have to weigh the pros and the cons. And you're also bound by New York trust law. You're bound by charitable trust law. So, which is somewhat different than corporate law. Now, the fact that it is somewhat, stricter is something that I want. It's a reason why I would set up a trust. And at the end of the day, and we've had numerous clients who've come to us on December 30th and said, I need to set up a private foundation. The only way to really ensure that that foundation is going to get funded and done is to set up a trust. It's much more difficult with a corporation. So, you have to worry, is the corporation, is the Secretary of State going to bounce it? With a trust, you set up your typical trust, you transfer your assets to it, and it's one signature, it's done. So sometimes we use trusts when we're under the gun, and a lot of times we have that. People don't always wake up throughout the year. They wake up, on December 30th. So, but with a trust, you have to weigh your pros and cons. Pick your poison, so to speak.
Yeah. So let me ask you, Jodi, if this is something that you've encountered much. So as you have explained, there might be good reasons for setting up a trust, and in particular because they may be the vehicle of choice for locking in the founder's charitable mission. And yet we've also seen that sometimes a trust may not be the right choice because of a number of reasons. It might be because it's cumbersome. You might need 3 directors, or I'm sorry, it may just be cumbersome because of UBTI. For example, New York has UBTI at the state level, Delaware does not, and there are a host of other reasons why maybe a trust is not the right vehicle and you're stuck with a corporation anyway. So one thing that we've seen, and I'm curious if it's something that you would be comfortable with or you've discussed with your clients, is the use of a donor agreement. So again, the donor agreement is a case where the donor comes along, and the donor is also the founder of the foundation. And before making, or contingent upon making the gift to the foundation, like whatever the amount is, millions of dollars, there's a donor agreement that says that the donor is only making the gift because of the foundation's promise to use the funds being donated for a particular charitable purpose, and the founder is acting in reliance upon that promise. And so the idea is that even if you are able at some point in time to amend the charitable purposes of the corporation, a la the certificate of incorporation or the bylaws, nonetheless, isn't there a binding agreement that would still tie the hands, as it were, of the successors to the foundation that would still commit the use of those funds to that original purpose? What do you think?
Interesting. I like it. I think you have to, I like the idea of the donor agreement. I think you have to make sure whoever drafts the donor agreement is unambiguous in what they want. Okay. We all know that ambiguity leads to disagreement, which only leads to settling somewhere where nobody's happy. So if you can draft that donor agreement so that your purpose is unambiguous and the use of it is unambiguous, I think that would be a very good plan.
Well,
It can't, I think it can only help you because it puts another layer onto not changing what the funds should be used for.
right.
And that's what you're after.
Well, you know, sadly enough, we see many cases where someone will fund the foundation. Maybe they don't have a donor agreement, but they have
Mhm.
specific ideas in mind. And for whatever reason, they didn't bring their kids into their confidence about what they had, in mind or what they wanted to use the foundation for. This is when they form the foundation, typically, as part of their estate plan, under their will or upon death. And suddenly the kids have all this money, they don't know what to do with it. So we've seen a couple of cases where clients have maybe recorded videos of themselves or written letters to their family, not like a legal document, just explaining what drove them to set up the foundation, what charitable, purposes they had in mind, what were their aspirations, what problems were they trying to solve. Is that something that you've ever seen your clients do, or do you think that's a good idea?
I think it's a great idea, but I think the clients have to understand that it's not binding and that the only thing their kids or successors are bound by is their conscience, their morality. A lot of times that's enough.
Right.
So again, it's another layer. It's another thing that they can do to make sure that all of their hard-earned money that they want used for particular purposes gets done. So
And but
one
what
of the,
about,
one of the things
go ahead.
one of the things you have to understand, and this goes back to the family dynamics, and this also goes to the succession and the unchanging, is that when you formulate an estate plan, okay, you have to be able to draw out of your clients the idea that how the children are going to feel when a large part of mommy and daddy's estate is given to charity, as opposed to them. Now, they may have sufficient assets. Their mommy and daddy may have, given them sufficient assets, but sufficient is always in the eyes of the beholder. Wealth is in the eyes of the beholder. So that's something you have to tease out as well.
And what about planning for contingencies? Earlier, you were talking about, polio vaccine. So what happens if you set up the foundation and maybe someone in the family, way back in time, several decades, maybe, perished from polio or is paralyzed? And what if they set up the foundation with the purpose in mind of finding a vaccine to or a cure for polio, and they found the vaccine? And now what happens to the foundation? Were they locked in this mission into the charter documents? Is that something that you talk about regularly with your clients? Like, so what if?
Typically don't, but we typically do fall back on a general purpose clause if the mission can't be satisfied. There is the ability to rely on the general purpose clause. I tend to stay away from that though, because so many of the things that clients today want, we can't foresee the future, and we can't even foresee these things. They sometimes have enough trouble formulating what they want to do today to formulate what they might want to do. I mean, I have problems getting my clients who are doing an estate plan and they have 2 little kids to focus on, well, what happens to all your money if, there's a disaster?
Could you touch on the foundation lifespan and succession before we go on to the next slide, because we're running short on time?
Yeah, I was going to say that. And you thought we wouldn't fill up the time. Foundations typically have been formed to last forever, perpetual corporations or trusts that, charitable trusts can go on for ages. But a lot of times, clients want to make sure that their mission is carried out and they know who the successors are and they can rely on the successors. But what about the successors to those successors? Are they going to stick to the purposes? And, all of these different permutations, they want to make sure that, after a while, it's done. They don't want to rely on generation after generation after generation. They put a sunset on it. After 25 years, that's it. And actually, I have clients who put in formulas into how much you have to spend each year.
Wow.
So that by the end of the sunset, it's spent.
Right.
Otherwise, if you just spend the 5% and you're a decent investor, you could end up with, having to really figure out what to do with all that money. So it's
Go ahead,
another
Jodi.
topic.
Right. I was going to just point out before we move on to the next slide that while certainly not your estate plans or your foundation documents, Jodi, yours are pristine, but
No.
in terms of but in terms of some of the things that I've seen, one of the saddest things that I've seen is where it's a trust and it's irrevocable or nearly so, is where unnecessarily the foundation is limited to making grants to various public charities, and it really curtails the foundation's ability to make grants to foreign organizations, to make grants to other exempt organizations like civic associations or business leagues, to make grants to individuals like scholarships, awards, or hardship or medical need grants. And so, not a problem with your documents, Jodi, but certainly something to make sure that people are aware of, and not to unnecessarily curtail a foundation's ability to do these things, because again, foundations are about control and about flexibility. And so there's no need to hobble the foundation. So with that.
No, which is why you need to go to somebody who understands the subject and
Right.
knows how to set up these vehicles.
So Jodi, could you please lay out the tax benefits to having a foundation?
Sure. Okay. Setting up a private foundation affords the client who's giving the money to the foundation several different tax benefits at different times in life. As I mentioned before, when a client is due to come into a large amount of income or is going to recognize a large capital gain, directing that income or asset with the built-in gain to the private foundation will give them a income tax deduction, and it will also there will be no gift taxes on it, there'll be no estate taxes on it, and the value of it will be an income tax deduction. Now, with private foundations, unlike public charities, there are lesser limitations, and they're pretty specific. You get 30% of your AGI if it's cash. You can donate. You can donate up to 20% of your adjusted gross income for qualified publicly traded stock. Other assets, there are a whole host of complicated rules, but a lot of times it's really what your cost was.
You mean you're limited to basis, limited to a basis?
Yeah, you're limited to basis, exactly.
I'll just point out that another factor that we see commonly is that folks want to stretch your charitable dollars. And so if they were to make a gift out of pocket, an individual to a foreign organization, or even one that's considered the equivalent of a public charity in the United States, or to individuals for scholarships or awards or what have you, or hardship grants, they wouldn't get a deduction, right, Jodi?
That is correct.
Right.
However, what's the fix on that, Jeff?
Well, so the notion is that these are all things that a foundation can do. Sometimes there could be a path or a specific approach for doing it the right way. But the point is, these are all things that can be done, and it's cost effective because you're using effectively pre-tax dollars. You're giving the cash to the foundation, you're getting a deduction for it, and the foundation isn't worried about income taxes because it's not subject to income tax, as you pointed out.
I actually have a memo to a client who wanted to donate to foreign charities. Said, you can donate to as many foreign charities as you like, but you're not going to get any charitable income tax deductions. However, if you contribute the funds to a private foundation, you will get your charitable income tax deduction, and then the foundation can facilitate getting the money to the foreign organization. So, there are ways around certain rules.
So with that, let's segue to the intangible benefits that we've discussed from time to time.
Okay. One of the main things that I like to talk to clients, specifically my older clients, about is retaining control. Okay. There's a certain type of client, an older client, a financial manager that do not want to relinquish control of their assets. However, they do want to fund a private foundation, or they're charitably inclined, so they want something. A private foundation, in that sense, is perfect. Why? Because the way we set them up, the person who's funding it can be the director, the officer, the person who makes all the decisions on grants, and really doesn't, during their life, doesn't really need anybody else involved. Typically, they have other people involved to do some of the heavy lifting. However, they hold sole discretion. So they keep control. They keep control of investments. They keep control of where the money is going. They keep control of all of that.
That's funny, Jodi. I mean, we always say that if real estate is all about location, 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 we see that foundations are all about control, controller, and control.
That is correct.
Right?
That is absolutely correct. You know,
What about using the foundation as a vehicle for next generation in terms of teachable moments and, kind of leading the next generation? Could you talk about that a little bit?
I'm glad you mentioned that because I love that. Okay. There's a lot of wealth around these days, and there are a lot of younger people who, because of the family wealth, may never have to work. Now, they may choose to work, their parents may, make sure that they work, whatever, but they don't have to. Even if they do, a very good way to teach somebody about wealth management, about giving back, about your place in the world, and
Paying it forward?
paying it forward, yeah, is by involving your children or others in the management of a private foundation. Private foundation assets need to be managed. People need to pick charitable causes, projects for use of the money. You need an accountant involved. And a lot of times you need lawyers involved. And these younger people can be involved in the first instance, observing what the parents are doing, but in the second instance, involving them. I know families that we've discussed where they give each child a task. They say, with respect to $10,000, I want you to find a grantee, some organization to give it to. But I want you to come back and convince me why we should give it to that particular organization. And, make your case.
Yeah, we've seen something similar. We've had foundations appoint maybe teenagers and college-age kids as junior board members. So they're not actually director, but they have the title of like a junior director, and they attend board meetings, and they might be given, and we've seen them given projects. It might be, report back to us on this particular charity, or report back on the situation, the environmental issues with respect to whatever, some sort of construction site. And so the kids feel like they're a valuable part of the foundation and making a real contribution. And so it engages them, and when it becomes their turn, they're already involved, they're invested in the foundation and what the foundation is doing.
What I also find is when you have the kids work on these projects, a lot of times they'll collaborate, and a lot of times you'll get them to share something and work together. So, it's a way to do that. I think that's one of the nicest things about it.
So just now segueing to our next issue with, when and why. So how do you and your client figure out what assets are best for funding a foundation? Ooh, that's a scary picture. Yikes.
Hey. My husband told me it looked like Ruth Bader Ginsburg.
Oh my.
I said, no, it's the scary teacher. Well, different points in your life, you may or may not consider a private foundation, but is it the right time? Do you want to start it now? Do you have the time? Do you care about the tax benefits? Do you need the tax benefits? What assets do you have available? You may have only liquid assets. these are things that go into, do I do it now or do I do it on death? I mean, I have many clients who wouldn't part with a dime right now because they're too afraid. However, on death, they think it's a great idea.
Hmm. And what if your
So-
clients aren't ready to make all these decisions up front? Is that the juncture where, is that where you would advise a client to set it up at death? Is that what you typically would do?
Yes, if they're not ready to make these decisions and they're not ready to set it up or spend the time, I think you kind of have to put it in their will, put it in a revocable trust that they're using as part of their estate plan, and let them articulate as best they can, and the rest is up to those who are going to run the foundation. We're going to have to run through these like in a minute.
Okay, go ahead, shoot.
Okay. Pension, IRA, deferred compensation. Those assets have income tax liability when the funds are distributed to an individual. The way to make that disappear is on a distribution of those assets to a charity on death. So they're perfect assets with respect to that. You don't want to necessarily do that while they're alive, because then the owner would be charged with the income tax liability, and they may or may not be able to use the corresponding charitable deduction. Qualified appreciated stock. It's a similar issue. You get a full fair market value contribution deduction, and the built-in gain disappears because you're giving it to a charity, and the charity has no liability on gains. Other related assets, there are requirements when you donate other types of assets. I'm going to put out a plug that if you have a question, I believe you have my bio and I believe you have Jeff's bio, that ask it. We didn't have enough time to give you all the answers.
Well, thank you, Jodi, and thank you, Jeff. You know, an hour just isn't enough time for two attorneys to talk about something as complex as this.
I told you, Jeff.
And we also have a lot of very detailed questions that have come through in the past hour. So I really thank the audience for submitting all of those. They are not in vain. We will be following up with you individually and making sure we can address some of those questions. I did have one that came through, and selfishly, because I'm representing Foundation Source, Jeff, I'm going to throw this to you.
I was going to say one question for Jeff.
And that is talking about private foundations formed as either a corporation or a trust. Does Foundation Source work with both of those types of private foundation entities?
Yes, in fact, foundation is really totally agnostic as to whether a foundation is set up as a trust or a corporation, or what state the foundation may be organized in. We work with clients in, I think just about by now, our 1,700 clients are about really across all 50 states at this time. And many of them are trusts, many of them are corporations.
Great. Jeff, do you want to just advance the last slide there so it can have show the email address and phone number? And so I'm going to just wrap everything up so we can stay under the hour here, and just want to let everybody know following this webinar, you'll receive a link to a recording in an email later on this afternoon. As a reminder, there's also a handout section where you can download Jodi's article and also some information about Foundation Source. And again, The email address to contact me is info@foundationsource.com or 800-839-0054. And if I can't answer the question for you, and because I'm not an attorney, it's likely I can't, but I can find out the answers and direct you to folks who can. So I really thank everyone for attending today. And with that, I will be concluding the broadcast. So thank you, everyone. Thank you, everybody. Have a great afternoon.
You.